You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand Dictation number 380 and the dictation speed is 100 words per minute. Ready? Start. We have heard the learned counsel appearing for the appellant accused and the learned counsel appearing for the state of Tamil Nadu at length today. The learned counsel appearing for the appellant submitted that the High Court erred in convicting the appellant by solely relying upon the testimonies of the relatives of the deceased. The learned counsel further submitted that the appellant should have been acquitted by giving him the benefit of doubt, particularly when the trial court disbelieved the prosecution's case and acquitted the co accused. On the other hand, the learned counsel for the state submitted that the High Court has considered all the evidence on record and rendered a well reasoned judgment which does not merit any interference by this court. With respect to the first submission of the counsel for the appellant regarding the testimonies of related witnesses, it is settled law that the testimony of a related or an interested witness can be taken into consideration with the additional burden on the court in such cases to carefully scrutinize such evidence. As such, the mere submission of the counsel for the appellant that the testimonies of the witnesses in the case should be disregarded because they were related without bringing to the attention of the court any reason to disbelieve the same cannot be countenanced. The counsel for the appellant next submitted that the benefit of doubt extended to his co accused should also have been extended to him. According to him, once the co accused were acquitted, the appellant should also have been acquitted. However, there is no such principle of law that requires automatic acquittal of an accused because of the acquittal of the co accused. The same is a settled position of law, which has been reiterated by this court in numerous judgments. The point to be considered is the nature of the evidence against the co accused that were acquitted in comparison with the evidence against the present appellant. A bare perusal of the judgment of the trial court indicates that the nature and quality of evidence against the appellant accused was distinct from that which was adduced against his co accused. The trial court noted that the other co accused were the aunt, mother, and grandfather of the present appellant. The court noted that the grandfather was 70 years old and could not even stand straight, let alone cause any injury to one of the witnesses. Further, with respect to the actions attributed to the aunt and the mother of the present appellant, the trial court held that they appear to be exaggerations and an afterthought, as they were not even included in the complaint. The court ultimately held that apart from the fact that the aunt, mother, and grandfather of the present appellant were present at the scene of the occurrence, there was no concrete evidence in the depositions of the eyewitnesses to indicate that they caused injuries to the witnesses. On the other hand, when it comes to the appellant, the evidence against him is consistent with the depositions in court being in line with the complaint and statements made before the police. The appellant is the main accused, who is stated to have attacked the complainant and caused him injuries, as well as hit the deceased on her head with an iron rod, resulting in her death. The allegations against the appellant are in line with the charge sheet. The wound certificate regarding the complainant and the post-mortem report of the deceased. It is for the above reasons that the trial court distinguished between the prosecution's case against the appellant and the co accused, and we see no reason to interfere with the same. The counsel for the appellant lastly argued that once the witnesses had been disbelieved with respect to the co accused, their testimonies with respect to the present accused must also be discarded. The counsel is, in effect, relying on the legal maxim false in one thing, false in everything, which Indian courts have always been reluctant to apply. This maxim has not received general acceptance in different jurisdictions in India, nor has this maxim come to occupy the status of a rule of law. It is merely a rule of caution. All that it amounts to is that in such cases the testimony may be disregarded and not that it must be disregarded. The trial court, as mentioned above, has given specific reasons for disbelieving the testimony of the witnesses with respect to the co accused and extending the benefit of doubt to them while convicting the appellant on the strength of the evidence against him. We find no infirmity in the approach of the trial court. We also find that the High Court, in the impugned judgment, has taken into account the submissions of the counsel for the appellant and considered the entire evidence in order to come to the finding that there was a free fight, as the appellant also sustained injuries and had even attempted to make a complaint. On the basis of the above, the High Court modified the conviction and sentence imposed on the appellant. The counsel for the appellant has not been able to point out any infirmity in the findings of the High Court. We therefore see no reason to interfere with the impugned judgment passed by the High Court. We find no merit in the appeal, and the same is accordingly dismissed. We have heard the arguments of the learned counsel appearing for the appellant and the learned standing counsel appearing for the state. It is the contention of the learned counsel appearing for the appellant that there is no direct evidence attributable to the role of the accused, and High Court has based the order of conviction on circumstantial evidence. He has contended that prosecution has not been able to establish the chain of events on the basis of circumstantial evidence, all leading to the one and only conclusion, namely the guilt of the accused.